Hello, everyone, and welcome. This is Federal Regulation of Medications Dispensing. So this will be Chapter 3 of the textbook. And then here are the objectives from the chapter. Alrighty. And I think there's one that I left off. So we are covering the vast majority of the chapter. I think there's one objective that I left off. So this chapter, a lot of it focuses on the Durham-Humphrey Amendment Act from 1951, which is part of the Food, Drug, Cosmetic Act, an amendment, and then there's been some obviously amendments within that as well too. But so this primarily deals with dispensing. So from earlier, we saw a little blip about it, but part of it is it distinguished prescription drugs or legend drugs from over-the-counter drugs. So up until 1951, from when the law was passed from 1938, the law didn't distinguish between that. And then it also allowed verbal transmission of prescriptions in addition to written and refills if authorized, once it gave it that RX legend distinction from OTC. Obviously, since 1951, we've had a lot of advancements, so like electronic prescriptions, things like that, but we didn't have that back in 1951. But those things have obviously adjusted with technology. So the FDA can classify as a prescription drug or a legend drug if it's unsafe for use unsafe for use except if it's under the supervision of a practitioner because of the toxicity or the method of use or for collateral measures. So so when it goes through the new drug application, right, through that whole process and stuff like that, the FDA will basically see that. So basically it has to be then dispensed with a prescription. Now, if it's dispensed without a prescription, it has an RX legend on there, right? RX only, I showed you on the label. If you dispense it without a prescription, you're going against that requirement. And one of the penalties of that is that it's actually considered misbranded then. So labeling of those dispensed drugs by the pharmacy. So in Chapter 2, the focus was the commercial container. In Chapter 3 here, we're looking at the pharmacy label a little bit more. So this is exempt from those commercial container requirements. So the list that I gave you prior, which is the commercial container. Now we're talking about the pharmacy container. So basically you get a prescription, you take the commercial container, you take the pills, let's say out of that, you put it in your pharmacy vial, that amber color vial, you know, the pharmacy label on there. What has to be on there? Does it have to meet the same exact things as the commercial label? The FDA says no. There are still some things it has to meet. For example, can't be false or misleading. So it does have some information that has to be on there. It's very minimal, but there is some information. Your book has a nice little like a review thing. It says this is what the Food, Drug, Cosmetic Act says, but most of your information is going to come from the state. So the state is pretty much going to have what the pharmacy label has on there, but there is some things. So for example, here you'll see the serial number, name and address of dispenser, for example, but there's a lot of things that aren't on there. So that's why you really have to look to your state. So when you start looking at what has to be on a pharmacy label, it actually comes from multiple places. Food, Drug, Cosmetic Act is one of them. If it's a controlled substance, you also have to look at that law. Then you have to look at your state laws. Depending on what type of prescription, is it an outpatient community pharmacy? Because you might have a label specific to that. Is it an inpatient medication order? So there's different types of labels depending on what type of practice setting you're in as well too, oftentimes. So the state will vary on that. Sometimes there's overlap as well too. Notice on that list there, or in the textbook, you'll see that the name of the drug actually is not on there from the Food, Drug, Cosmetic Act, and that is correct, but your state will definitely have the name of the drug is required to be on the pharmacy label, so you don't have to worry about that. Again, this is not a single list just from here. You have to put all of the resources together of what's required, and this is just one of the resources. Now, keep in mind your state or your your state has a list too, but your companies will as well. So every company is a little bit different. Many companies are in multiple states, so they have to think about how do we comply with all these different states. So many states go above and beyond what most states require. So again, as you're taking these exams, not only mine, but your state exams like the MPJE, keep in mind your company is probably going above and beyond what it is. So do not get confused with what the company requires, because if you're sitting there looking at a list and go, oh yeah, this is what my company does, it may be above what the law requires, and that's not what you're being tested on. So expiration date and beyond use dating. So these are two important concepts for a number of reasons. These apply in multiple situations, and this is a very confusing topic for students, so I do have a mini topic on this, and this is one place where we'll see it, but there's other places throughout the chapter and different times that we'll see it as well too. But if you think about an expiration date, the manufacturer of a product has to do studies basically to determine when their product expires in that packaging that they package it in. All right, so obviously there's certain standards, the FDA approves all that and everything, and then the USP has these requirements basically, and it's defined as the manufacturer provides expiration date of the product. Removing a product now from that manufacturer container, right, that has done the test, okay, when you put it into another type of container, you can't assume that that manufacturer expiration date is going to stay the same because the tests were done for that container. So that pharmacy vial, now that you're putting that medication in, okay, you can't say that that manufacturer date is going to stay the same. So that's when we get into beyond use date, or the date after which a drug should not be used. Okay, so not the same thing as an expiration date. Now, the beyond use date can never exceed the manufacturer's expiration date, but it could be less as well too. So there's various things you have to consider. First of all, the drug itself may have something in the labeling that says, okay, once this product is open, this is how you determine the beyond use date. So the product specific labeling may give you information on it. Maybe your state law will give you information on how to determine certain products when you put it in a pharmacy vial maybe. You have to think about the container that it's in. We have FDA and USP standards. So there's multiple things to think about. There's also different times we think about beyond use dating as well too. So it depends on the type of activity. So for when we take like pills out, for example, and put them in a pharmacy vial, the U.S. says, unless specified elsewhere, such as in the labeling or something like that, an absence of stability test to the contrary. Because if there's a stability test that says, hey, once you take this out of the manufacturer's container, it's only good for a week, obviously you have to comply with that, right? But if there's absent some stability test like that, the beyond use date shall not be later than the expiration date of the manufacturer or 1 year from the date of the drug is dispensed, whichever is earlier. That's a USP standard, okay? Many states use that standard, all right? Now, you've got to look at your state, okay? So I can't sit up here and say every state uses that standard because I know some that don't, all right? That's a general statement. Please don't quote me on that because, again, every state's a little bit different, okay? That's just an example of what some states do. So, for an example, if you pull off a bottle off the shelf and of, let's say, like a Lipitor pill or something, and it says it expires 6/1 of 2025. So what does that mean? That means those pills in that commercial container expired June 1st of 2025. So depending on what date you're dispensing it, right, can you use that date? Well, again, you have to look at exactly what that date is that you're dispensing it. If you're going to put it in the pharmacy vial, is that 1 year from, it shall not be later than the expiration date on the manufacturer container or 1 year from the date it's being dispensed. So if you're dispensing it 6/1/24, okay, you have to, if it's longer than that, right, if it's prior to 6/1/24, right, that expiration date is longer, right, but the longest you could put on that date because you're taking it out of that Lipitor container is only 1 year for the beyond use date, all right? So if you open it prior to that 6/1/24, even though the expiration date is good till 6/1/25, you can only put a 1 year beyond use date. So 1 year from the time that you're dispensing it. All right. So again, depending on when you're listening to this, I don't want to give you a specific date because people are probably going to be listening to this different time frames. So 1 year, the BUD shall not be later than 1 year. I'm sorry, let me say this again. The BUD shall not be later than the expiration date on the manufacturer container, okay, or 1 year from the date the drug is dispensed, whichever is earlier, okay. So there should never be a BUD longer than 1 year, okay. But if the manufacturer date is earlier, obviously it's going to be sooner than that. So if you pull a drug off the shelf and it expires on the manufacturer's expiration date 3 months, you're going to be using that because 3 months is sooner than 1 year. Okay, so you got to use that. So many states, like I said, do require the BUD on the pharmacy vial or label. So you're going to have to do that as well. The book gives an example. So look at the book and actually gives like a day's date that you're dispensing. It gives the manufacturer's expiration date and it gives the date of that. So if you want to look at an exact date of when you're dispensing and everything. Now, like I said, there are other variations of state law that may be found. So, you have to you have to research and know exactly what your state law is. And again, that's all depending on assuming that there's no labeling, there's no stability test out there as well too. So keep in mind that there's BUDs for compounding that you have to follow. So this is not, every time you hear BUD, beyond use date, this is not what you're going to go to because there's going to be beyond use dating for compounding. There's going to be beyond use date for repackaging that is different. So repackaging is not dispensing to a patient, all right? We're going to see repackaging that is different, and that's a little bit later here. So again, we're going to have an optional, well, I'm probably going to have you watch it, but it's a mini topic on BUD just because I know this is confusing. Every time someone hears beyond use date, they automatically go to this concept of 1 year, and that's not the case because there's different times you're going to use beyond use dating in different circumstances. This is just one circumstance when you're dispensing a drug to a patient in a pharmacy vial. So we might have times where a prescription is switched to an OTC. Different ways that can happen. But basically the OTC status requires that a product be labeled adequately to the consumer so they can self-diagnose, treat, and manage without the practitioner involvement. Remember, the prescription needs the practitioner involvement. They need to be able to prescribe, and they need to be able to have that oversight. OTC has to have that label that's geared towards the patient to be able to use safely, and that's geared towards that layperson. So if something is prescription, right, and they want to switch to OTC, there's times that can happen. It can go through an NDA or it can go through an OTC drug review process. So the pharmacist must abide by the label in the situation where there's different manufacturer products with the same drug. So you might have a drug that's an RX or an OTC depending where the process switches. So you have to keep that in mind too, because sometimes there's products that are different manufacturers looking for a switch where the other one isn't. Occasionally that has happened, not too often. So there's a little section on professional practice considerations. So this kind of looks at how federal law and state law mesh together a little bit. So as Durham-Humphrey Amendment says, it allows prescription drugs and OTC, those are the categories. Prescription drugs can be called in. Prescription drugs can also be refilled where authorized. Well, that authority comes from pretty much state law. So first of all, who can prescribe, that authority also comes from state law. You have to look from your state law and who can prescribe. In general, physicians can prescribe, dentists can prescribe within the scope of their authority when they're treating basically conditions of the mouth and the teeth. You can also have like podiatrists can prescribe when they're practicing within the scope of that as well too. Vets can prescribe for when they're practicing with the scope treating animals, for example. Most states allow certain mid-levels to prescribe. So as long as, the states have that list of who can prescribe, and you understand that, the states give that authorization, all right? So that's one thing. Then the refills, right? States will say, you can have up to so many refills per year, da da da. Now, controlled substance law at the federal level says this too, but then the prescriber can put certain amount of refills as well too. Sometimes there's limitations, like the mid-levels might be limited on how many they can put or something, or the quantity as well. But you have to look to state law for that. But we do need to understand as pharmacists, I guess, where the authority is, what prescribers can do. Even though that's their obligation, we also have to have an understanding too, because we want to make sure that we're dispensing legal prescriptions as well. There's a section on Plan B, emergency contraception, and conscientious objection. So read it. It is a good history of it. It's a very back and forth type thing. Plan B went back and forth for years. It is available now without a prescription for the age restriction is gone. It used to be available on the same label box for OTC and prescription, depending on the age. It was very unique. I think that was the only time I saw a product that had RX and OTC on the same label, but that has since changed. But the Plan B status, other types of emergency contraception besides Plan B, there's a newer prescription product. Your textbook mentions that as well. So there's been a little bit of updates on that. Now, some states have passed laws and rules on the issue with conscientious objection. Companies may also have policies as well. So this is kind of scattered all over the board. So depending on what state you're in, some states may allow you to decline to fill beliefs based on your moral beliefs. Some may not. Some may make you have a protocol in place. So you really have to check on your state, but that really comes from the state level. A couple states are silent on it as well too. In general, pharmacists do have rights to I guess say that they want to decline something. That's the general philosophy. But pharmacists are never allowed to obstruct a patient's legal right to receive a lawful medication, I guess. And what I mean by that is if a patient has a legal prescription, a pharmacist might be able to decline it and say no, but a pharmacist cannot take that prescription and say, not only am I not filling it, I'm going to rip it up. You have to be able to give it back to them, if you will, and allow them to go to like a different place. Now, there have been various changes in legal cases over the past few years at the federal and state level, and this has caused some possible conflicts of law and guidance and policies depending on what state you're in. For example, the Roe versus Wade was overturned at the United States Supreme Court, meaning states now can decide on, I guess, abortion rights. And then some states have gone and passed laws saying it's illegal at certain time frames to have abortions, but yet there's certain medications that impact abortions, and then pharmacists can dispense them, and they're approved up to so many weeks. So pharmacists in certain states face potential penalties for dispensing that if the state law says you can't be involved with an abortion, I guess. So, there's certain organizations that are following that because there's a number of states that pass laws where pharmacists dispensing products put themselves at risk of either discipline or criminal action because of dispensing certain products, actually. And then the federal government put some guidance out actually saying that it could be against civil human rights if we decline to dispense certain products. So there's been conflicts. There's been, again, state versus federal laws, guidance out there, and policies that are against each other as well too. So it is kind of all over the board right now. So I guess you kind of got to see what your state says and what your company policy says as well too. But I'm not going to test you on that topic just because it is really all over the board. But I do want to make you aware of what's going on. The book is updated, at least at the time of as I talk, because who knows, things could change tomorrow. But at least at the time as I'm recording this, it is accurate. Collaborative practice agreements, most states do allow them. That's where prescribers and pharmacists can work together. Pharmacists could do limited activities under the collaborative agreement, like drug therapy management. Some states do allow pharmacists some prescriptive rights, some don't. But those that don't, then usually the doctor could prescribe, and then the pharmacist could change, like the drug therapy, things like that. So again, you got to look to your state. Again, state law dictates who can prescribe, but they also dictate who can dispense. It's generally pharmacists, but in some states, the prescribers can also dispense. So there's a section on written patient information, prescription drug labeling for the patient. So part of the labeling, and you'll see this like in the package insert if you open it up, but it's geared towards the patient. So again, this is a long history of really political reasons that led us to where we are today. So I encourage you to read the background, because if you understand the background, you kind of understand of how we got to where we are today. But this is another confusing topic, and I'll have a mini topic on it as well. So how is it that we can have consumer medication information? How is it that we can have patient package inserts? And how is it that we can have med guides? Well, it's really political in nature. So if you read the background, the few pages of background in there, you'll get, I think, a good sense of how we got to where we are today. Now, over the last 10, 15 years, the FDA has been working on transitioning that to one-page document for every single drug. And thankfully, they put out a proposed rule recently on it. Now, it has not come to fruition yet, but hopefully in the near future in law does not mean tomorrow or next month or near future, but it might be in the next few years. It'll be after you get out of school, I'm sure, but it's going to be called PMI. Okay, patient medication information is the hope. So for right now, we still have CMI, PPI, and med guides. CMI, though, is not regulated at the federal level, meaning there's not a rule or regulation on it. However, you still want to give it to every patient. It is driven by the private industry, if you will, usually by companies, and then or like an organization, and then the companies buy it, and it usually is available for every drug. But the PPIs and the med guides are regulated by the FDA, and they are required for specific products. And when they're required for specific products, you have to give it out for every new one. And then for the refills, basically for that's the community level. And then for inpatient, it is amended for the PPIs for the first time, and then for every 30 days. The med guides is amended for when, I guess, the patient requested, or if the physician or the prescriber would like the patient to have it. So those are the requirements for PPIs and med guides. I am not going to test you on the products that are required to have them. Med guide list is a growing list in terms of it can be added on. Like I said, once PMI, the rule is finalized, all drugs are going to require it. Given CMI, we want to do it for everyone. You should be given CMI for every drug. If there's a med guide for a product, let's say Coumadin or warfarin, if you give CMI, that's fine, but you can't substitute CMI for a med guide. You would have to give the med guide too. So if you do not give a med guide or PPI when it's required, that's misbranding, okay, because it's an FDA requirement, all right? So again, if you're trying to skip the reading or cut down on the reading, this again is something that would probably help you a lot to understand why we have the current system we have by taking the time and reading the background of this. So what about approved drugs for off-label indications? So when a drug goes through the approval process, it has indications that it's getting approved for. The FDA approves it for certain indications. That's a labeled indication because it's in the label. But oftentimes it is, through studies after it's on post-market or something like that, it's like, oh, this also helps with this condition, right? And we know through scientific evidence, and we know through that kind of thing, that it's also commonly used for other things. And it's actually quite common. Sometimes the drug company goes through, a label change and they update things. Sometimes they don't. But there's studies out there that show it's pretty common that this happens. It's not illegal. It's not against, any standards or anything. The FDA is aware of it. It happens. What you have to know, I guess, though, is that when you're dispensing something, um, you know, the doctor doesn't, or the prescriber does not have to put on the prescription what the indication is. But in general, they might. But number two, if and when you're counseling, um, during that counseling session, that's where you can have a discussion about what it's for. You might find out that it's for other indications than what is in the labeling. And then also, what are the normal doses and things like that as well too? Because if you get a prescription that's for the dose is way off, right? But sometimes the indications are different, like a certain dose is for a label dose, but maybe an off-label is for a little bit different dose as well. So sometimes that's why it's important for counseling that the patient understands exactly what they're using it for and stuff like that as well too. But you should be concerned if something looks like an unreasonable risk, right? Like a liability concern as well too. But it's not illegal. It's not wrong to fill for an off-label use. You just have to use your professional judgment, have discussions with prescribers, I guess, if there's any concerns, and take risks or take steps, I guess, if there's concerns. My recommendation is always is to document and make sure that you jot that down, because it's hard sometimes to remember a little bit later after you fill many, many prescriptions exactly what happened during those discussions. So generic substitution and the role of the Orange and Purple Book. So the Orange and Purple Book are guidances put out by the FDA. They're not laws, they're not legal requirements. Now, the state may adopt them as such, but by the FDA, they're guidances. These help states, or pharmacists, if you will, unless the states want to adopt them as law, to substitute generic equivalent products. The Orange Book is for our traditional drug products, like our, generic tablets, if you will, capsules, those types of products. The Purple Book is for the biologics. The Purple Book is newer. The Orange Book has been around for a longer time. So these not only help us with these generic substitutions, they also list approved products too. So remember how I said NDC products or NDC numbers don't mean that there's approved drugs, but if a drug is listed in these, it means that it's been approved. So you're not going to find non-approved drugs in an Orange Book, all right? And I've already discussed that before. But I want you to understand the rating system. So like the first letter being A or B, you don't have to worry about the second letters, but understand what the A or B is in the Orange Book, understand what interchangeable and biosimilar means in the Purple Book. I do have a mini topic on this as well, I believe. Yes, I do. I'm always positive. I'll go back and double check on that, but I think I do. And then I also have an exercise for you guys to do as an activity or an assignment for this as well too, these topics. So just keep in mind that this is not a law, but your state may adopt it as a law. So we will look at it when we get to the state side as well. So our drug supply chain security. So when the New England compounding tragedy struck, the Drug Quality Security Act included that part, but it also included a section for the drug supply chain security. Now, we had a PDMA amendment back in the 1980s, which is important, but this also was needed as well because of some issues. So we have our normal stream of drug supply chain, basically starting the manufacturer, going to the distributor, all the way down to the pharmacy, who then pretty much dispenses to the patient. That's the general scheme. But we want to prevent drugs basically from entering the gray market, if you will, getting in. So we want to prevent drugs from somehow making it in that shouldn't be, and keeping our drug supply chain secure. So typically the term you hear is pedigree. So we want to track drugs from the time they're made all the way to the time that they're dispensed if possible. Obviously there's exceptions, but that's generally what we want to do. So states started having their own pedigree systems, but the federal government stepped in and said, well, wait a minute, this isn't working. This is a patchwork of things. It's really hard to do. So we're going to come in and we're going to do a federal one. And over the last 10 years or so, they've been working on it, and it was supposed to be finally implemented, enforceable in November 23, but then they announced that they would give another year for that enforcement. And I think the book came out right before, yes, I think it came out right before that was announced. So your book might say it was enforceable in November 23, but it does not say it was another year. So November 23 is correct, but then it was delayed by a year. So I don't think that's in there. But you won't be graduated by then, depending on when you're listening to this anyway. So it's really not relevant to you, but just so you know as an FYI. So anyways, the PDMA was more for samples and manufacturers, distributors. Like you can't have samples in the community pharmacy. There's very limited times you can have it in a health system pharmacy requested by the prescriber, for example. So for this track and trace, I have a couple slides coming up on that. That's the new drug supply chain security, and that's the one that's been in works for the last decade or so. I do want to make a note about importation. In general, we can't bring in drugs for personal use from outside. There is a limited exception for like a 90-day supply if there's a drug not approved in the U.S. that we have a serious condition for. We just can't go get it ourselves, though. We do have to go through like a step process. Some people think that they can just go across to Canada or Mexico and get it. People do that. That's not right. But the FDA doesn't have resources to track everyone. But there was a Trump-Biden approach where some states have considered importation from Canada. They have put forth some plans, and the FDA was told that they have to come up with some kind of mechanism to approve these plans, or some way to approve plans that could prove that they were safe, I guess, or they had ways to prove that the medications were safe. A few states put forward some plans, and they've been sitting there kind of idle. Excuse me, at least the FDA wasn't looking at them. Florida was really pushing for it. And I just saw in the news this past week, from when I'm taping this today, that the FDA was being pushed by Florida, and the FDA actually approved Florida's plan. So where I'm sitting out today, if you're interested in reading about one of these states, you could look and research and see where it's at. But it seems like a state might actually be allowed to import drugs from Canada. Now, they have a safety net over the plan, if you will, and we'll have to see what happens because, again, it was just approved by the FDA. Obviously, it has to be implemented and stuff like that, but there's supposed to be these safety measures in place to make sure that drugs are being safely brought in from Canada. Alrighty. So the track and trace law, this is the newer part of the law since 2013. It's taken about 10 years to implement. Like I said, it's just recently been delayed for another year for enforcement. But basically, track and trace from the time the drug is made at the manufacturer to the time it's pretty much dispensed to the patient. Pharmacy's obviously in there. So the key provisions is that the manufacturers and repackagers put a unique product identifier on certain prescription drug packages. There's product tracing, trading partners, including pharmacies, dispensers, all the way down the line stream are providing information about a drug, who handled it each time. So that's the pedigree. We can see where it went basically down the chain of supply, if you will. The product verification systems in place to verify the product. Detection and response, we're looking and we're quarantining or investigating and quarantining suspect products. We're notifying the FDA and others, stakeholders above us. Wholesaler and third-party logistic providers are getting licensed. Drug distributors to report information to the FDA, such as licenses and statuses. So there's this, extra safety net, if you will, and actually we're coming down to the products and we're tracing them as they're going throughout the drug supply chain, if you will. Now, trading partners are to provide subsequent purchase information at the lot level product tracing. So lot level transaction information, history, and statement are to be kept by the partners, such as the dispenser, which we are for at least 6 years. So we are also, as pharmacies, to confirm our trading partners, either directly through the FDA or the state authority. We also have to have these systems where we're handling suspect illegitimate products. How do we identify them? And there's guidance on this. I just took a couple blips out from them so you have a basic understanding or general idea of what that means. So if we are distributing, meaning we're giving a drug to some other entity, if you will, other than the consumer or the patient, okay? In general, you have to have a wholesale license, right, to be able to do that. But if you're just doing like on a, if another pharmacy needs something like on a one-time basis or something like that, do you have to give that transaction data? If you're doing it on a normal basis or something, yes, you do have to do that transaction data. But there are some exceptions when the distribution is between entities affiliated amongst each other, or when the pharmacy dispenser provides a product to dispenser on a patient-specific basis. So if a pharmacy calls another pharmacy, it's like, hey, Mrs. Smith is here. I don't have this drug. Do you have it? It's on back order. And the other pharmacy, from the wholesaler or something, if the pharmacy says, yes, I do have it, and they're transferring it specifically for a patient, then they wouldn't have to meet this. That's what the guidance is saying. So there are times that you may not have to pass along the transaction information and data, but for the most part, if you're doing a distribution, right, then you have to meet those requirements. There is still some guidance out there that was being finalized or done, and some more recent one that came out, but the FDA website has it on there. That's a little bit outside the scope of the class, but if you're looking for more information, it is out there. Oh, and I put on the slide there that it's enforcement is off till November 2024, but I do not believe that's in the text. FDA can inspect whenever there is drugs in there. In general, you're not going to find the FDA just going into your everyday pharmacy. They will get involved in compounding type things if there's issues there, especially when there's more issues with like the concerns with them being like a manufacturer type activity. But in general, you're not going to see them in your day-to-day pharmacies. They do not need a warrant, but they must show credentials and notice of inspection. And the inspections must be at reasonable times, reasonable limits, and in a reasonable manner. There are other laws related to the food, drug, cosmetic debt that are mentioned in the textbook as well, like use of alcohol in pharmacy practice. Community pharmacies may use tax-paid alcohol for compounding. Purchase from authorized retailer wholesalers. Tax-free alcohol, 190 proof, may not be obtained or used by community pharmacies, but may be used by specific entities for specific purposes. And must be stored in a locked stateroom. Actually, I will not be having a test question on that. I can tell you that. So you can cross that off for test questions on the alcohol one. The Poison Prevention Packaging Act is to protect children from accidental poisonings, and there is a separate reading on that. There's a federal guidance, so that's important. So we need to look at that as well. I have a slide on that next. So this was a law passed in 1970 by Congress for the intent of protecting children from accidental poisons from household substances. Drugs are under them, OTC and prescription, okay? So obviously there's other products under there too, but we have to worry about it because when we dispense prescriptions, we have to have a safety cap on there. OTCs also have to comply as well too. So I do want you to download and read this healthcare provider guidance document on it. It comes from the Consumer Safety Product Commission. The link in the middle is the current document approved by the agency. There is another document out there that was put together by the, looks like employees of the agency, but wasn't officially approved by them. So let's stick with the original one in the middle that has been out since 2005. That is the officially approved one, but I did want to show you that there is another one out there as well too. So you can look at it if you want. It's just not the official one, I guess. Now, I'm not going to test you on all the drugs and the quantities, which probably could be tested on the MPJE, so you got to decide what exactly you want to learn and memorize. But I do want you to understand what are your obligations in terms of dispensing. You have to put a safety cap on unless the doctor or the patient, the doctor or prescriber requests otherwise, or the patient requests otherwise. Do you have to have it in writing? No. Is it for all drugs? No. There are some exceptions, okay? Do you have to know all those drugs and exceptions for this class? No. Might you need to know them, or should you know them for the MTJE? Yes, they're open for testing. How about OTCs? Yes. Are there exceptions? Yes. Like a manufacturer can make a product, if they make a 2, 4, 6, 8 ounce, let's say, in a cough syrup, they can pick one of those that does not comply as long as they mark it. Do manufacturers have to comply? Yes. What if they don't? Well, it's going to, but let's say you're dispensing it from, that's OTC. What about if you're dispensing a prescription product right in the manufacturer's container? They also have to comply. What if it's not compliance? Well, you just can't give it out in non-compliance. You still have to comply as well too. So there's a bunch of, not a bunch, but there's a number of Q&As at the end. I would like you to read those too. Those might be helpful in everyday practice settings. So that's at the end of that document. So these are some things, the main points, I guess, of the law that come from the book, if you will, as well, and from some of those Q&As as well. So the book is a couple pages, and then the document as well. And these are some of the things I just said. And these are some of the things I just said. Sorry, I guess I should have been moving along when I was saying them. All right, there's another law I just want to mention briefly. It's called the Federal Anti-Tampering Act. I just don't want you to get this confused with the Poison Prevention Packaging Act. This is a completely separate law, although it's similar in nature. We have our products over the counter. Most of them have to comply with this. And this is, the product has to have something on there to show that it has a seal on there that it wasn't tampered with. So if you pick like something up over the counter, it might have like a little cellophane seal around that says do not use if broken, or it has something around there, so when you buy it, you know that it has been sealed. But this was in a response to a tampering of a Tylenol product. So it happened back like in the 1980s or so. And I actually learned about this case in law school because the Tylenol, I think it was up in the Chicago area, someone went in and picked up a bottle of Tylenol off the shelf of like a grocery store or a drugstore. And at the time, there was nothing that a requirement. So someone literally took the cap off of this Tylenol and they poured a poison on top of the Tylenol. So someone bought this bottle of Tylenol, took it home, and then patients took it, and it happened to be a husband and wife that took it at the same time when they were about to go to a funeral. Yeah, they were about to go to a funeral. They take these Tylenol. They were at the house with some other friends and family about to go to a funeral, took this poisoned Tylenol, if you will, and they both literally dropped dead like at the same time. So a very sad situation, but the reason why we learned this in law class is because neither the husband or wife had their will in place. So who got the money? Did the husband die first? Did the money go to the wife and then the wife's estate got it? Did the wife die first and go to the husband and then it go to the husband's estate? So it was like down to like the minute, because I think maybe the one spouse died a few minutes before the other or something like that. So that's why we learned about it in law class. But in terms of the tampering, what happened after that tampering is they passed this law. So these OTCs require that tampering, but it has to be a visual seal barrier on products to show that it's been opened or, if it has been opened or tampered, okay? So obviously patients shouldn't be buying something if it has. Now, obviously if, it was handled improperly or something, does it mean it's been poisoned? No, but a store should not be selling it and a patient should not be buying something. So, and it applies to consumer products, also to cosmetics too. There are some exceptions in there, okay? You don't have to go through and learn them or anything. I don't even list them there, but I do give you the reference if you want to look more into it. But if it's not complied with, it's actually considered adulterated and or misbranded. It's also regulated by the FBI, FDA, and USDA as well. There's multiple agencies that can regulate this. So this is a comic I saw years ago in, I don't know if I saw it in the magazine or online or something like that, but, I started to chuckle when I saw this, and I can't remember, one of my kids was like, "What are you laughing at?" And I show them, and they're like, "I'm completely clueless." So this actually goes with that, that law, the anti-tampering, right? So do not consume if seal is broken, right? So that's what it is. You can't consume if seal is broken. So there's the seal telling the shark, do not consume because I'm broken. So drug advertising, like I said, I will not test you on. Drug advertising is regulated at the federal level through the FDA for prescriptions, FTC for OTC. So that would be like your direct to consumer, things like that. Advertising for like the store level, like Kim's Pharmacy, something like that, is going to be regulated at the state level. So we'll see that at the state, but you won't be tested on the federal level for me. Alrighty, so that's chapter 3, okay? But don't forget you have the compounding section, and then we're going to have some mini topics, and make sure you look at the CPSC document as well. Thank you.